Hello, everyone. Welcome to Court with Krissy. It is not the Three Stooges, but they are all a little loopy. And who is the craziest one of them all? It is obviously the pro se, who is facing 5 felony charges and heading to trial soon. But don't worry, the judge brought him back up. He was given a standby counsel. I hope you like it. Court with Krissy is now in session.
Joshua Jacob Hillier. This is file 23-6652FH.
For the record, Your Honor, Mike on behalf of the people.
Thank you, Your Honor. Richard Trush, I stand by counsel for Mr. Hillier.
Thank you and welcome, sir. You are Joshua Jacob Hillier, correct?
Yes.
Okay, welcome back, Mr. Hillier. Just so you're aware, I don't know if you could hear Mr. Trush, but he's here obviously as your standby counsel. Mr. Rollis here on behalf of the people via Zoom. You're obviously joining us via Zoom, and I'm in here in person in the circuit courtroom for Otsego County. So, Mr. Hillier, first, have you been able to maintain good contact with Mr. Trush as your standby counsel since his appointment?
I've talked to him a couple times. Yes.
Okay.
I haven't had a phone the whole time, so.
So communication is probably difficult with that.
Yeah, when I have had one, I've reached out and talked to him.
Okay. Well, as you know, Mr. Hillier, just to make sure it's clear, I appointed Mr. Trush as standby counsel because ultimately I thought it would be a good idea so that you could communicate with him when and if you needed to regarding the background processes. In general, do you think you've been able to have that input from Mr. Trush?
Not in very much depth. We discussed what he's, I guess what he motioned for last hearing. And after today, we're going to talk about what my obligations are going to be to continue.
Well, let's talk about that for a moment because I recall specifically making a requirement for a couple of things. One, that any motions or notices to be filed within the next 30 days. Are you suggesting, did you file such a motion, Mr. Trush? Is that what he's suggesting?
No, so I think what he's referencing is when I had spoke to him initially after the appointment, he had asked for 2 pieces of information, basically. So he had discussed with me that he wanted some information on filing an interlocutory appeal. I sent him a packet that put out my SADO about how to file that sort of information if he wanted to. That information went out to him very recently, though, I think within the last week, mostly because I could not get in touch with him to get an email address for him to send it to. So I sent that information out to him. He asked me about also information about finding an independent lab to test the sample. But admittedly, I have not been able to find an independent lab that is willing to test a controlled substance sample.
Is that the motions you were talking about, Mr. Hillier, is the questions about the interlocutory appeal and an independent lab?
I believe so. I missed what we talked about on the first one, but yeah, the lab one and the appeal.
Yeah, and that's what Mr. Trush said, is that the first time you talked to him, you had questions about how you could go about filing an interlocutory appeal regarding my decision on your prior filed motion. And the second thing he said is he was trying to look for but could not find an independent lab to try and test the substances at issue. Were those the things that you were talking about?
Yeah, they were.
And so what is your request to the court for today, Mr. Hillier?
I'm sorry, I don't, what am I requesting the court to do?
Well, yeah, let me put it this way. This hearing is set for a couple of different things. It's set for a final status conference and a plea cutoff. When the first statement, though, that's made by you in response to my question is that you might want some more time to talk to Mr. Trush, it brings up a question to me as to whether or not you're asking for that, for more time to be able to talk to Mr. Trush. And so I want to just clarify what you're asking for, if anything.
Okay, yeah, I would like some more time to talk to Mr. Trush to make sure that I'm doing things properly with the court.
The thing I want to make sure is clear, though, I'm going to hear from the attorneys about this request, But you know that I had this set for a plea cutoff and a final status conference today, right?
Yeah, absolutely.
And you have not been able to be in contact with Mr. Trush as much as you wanted because you said you didn't have a phone, right?
That's right. Yep. I don't think I have a phone right now.
Well, what are you on right now? How are you joining us?
My laptop.
And does your laptop have internet capability? I know the answer to that is yes.
Yes. Yep.
Obviously, you could email Mr. Trush at any time you wanted.
Yes.
And you haven't done that.
I could. I responded to his email. That's why I called him right away.
Well, I thought you didn't have a phone.
I didn't have a phone the entire time since the last time that we had been in court. I went without a phone for 3 weeks.
Mr. Hillier,
Then I got it turned back on.
What I'm not trying to be is difficult, Mr. Hillier. What I'm trying to be is clear and implying to you that it's my belief that outside of a phone, you also have other methods to communicate with Mr. Trush, and it sounds like you've not been making use of those. So my suggestion to you, even before I hear from the attorneys, is that if by some way I'm convinced to adjourn today, I'm not going to find it a basis to adjourn again if you're not making use of the communication equipment that you do have. Because you have the ability to email. And if email is the only thing you can use, the good thing about email is you can certainly type out any questions you have and Mr. Trush can answer. It might not be as convenient as talking on the phone, but Mr. Trush also happens to have a physical office. And so you have the ability to meet him in his physical office. And there's probably other accommodations that Mr. Trush could make as well, though I'm not going to force him to talk about those on the record. The point is, if you're telling me you haven't had enough time, you need to know that the follow-up that I'm going to have is what efforts have you made? Does that make sense to you?
My efforts has all been studying to make sure that I'm doing things properly to appease you guys.
Let me tell you this. I want you to research and I want you to try and make sure that you do things correctly. That's obviously important to me. But if you're telling me that part of your concern is you haven't had enough time to contact Mr. Trush, then my immediate and loud response to you has to be do better in getting into response with him. Because there's no possible way he can communicate to you or give you legal advice if you're not constantly in communication with him. So I'm going to hear from the attorneys now, but I hope I've impressed upon you the fact that if you're not being in communication with your attorney, I will not be likely to adjourn again on the basis of your lack of ability to hear from him. Mr. Rolla, the circumstances are clear that today was set for what I view as a final status conference and plea cutoff. You can probably tell that my concern is I want to make sure Mr. Hillier has an adequate chance to fully talk with Mr. Trush. He may have already had it. Let me ask it this way. Did the people have input about, or did you have an objection to the court potentially adjourning for another month to give that final opportunity?
Yep, Your Honor, specifically to avoid any possible appellate issue, the people have no objection to one more adjournment. I would note as well for the record that there was a plea offer extended for counts 1, 3, and 5 for dismissal of counts 2 and 4. If this matter does go to a trial, it's probably going to take a 2-day trial since we have, I believe, 9 witnesses, 2 of which will be lab personnel. Thank you, Your Honor.
Mr. Trush, given the statements of Mr. Hillier so far, do you believe it would be advantageous to him and to you to be able to have one more opportunity to discuss?
I guess, can I ask Your Honor, is there a trial date set at this point?
There's not.
I don't have an objection to an adjournment. I would suggest to the court that I think it's prudent at this time to set a final status conference to docket trial dates as well. Based on my discussions with Mr. Hillier, I mean, we're headed to a trial on it. I do not get the impression from him that he is interested in plea discussions much at all. So, I mean, I'm happy to go through some of those things with him. I had discussed with him when I did talk to him last week, in this past week, you know, the next steps are going to be his obligations to file witnesses, his obligations to file jury instructions and those things in preparation for the trial date.
So, Mr. Hillier, it sounds like while the attorneys, neither one of them have an objection to you having more time, also think that ultimately we're going to need a trial in this case. Is that your belief as well?
Yes, Your Honor.
Then why don't I just set a trial? I want to hear your input. Why don't I set a trial and set it out 60 or 90 days to give you plenty of time to talk to Mr. Trush and then have a trial? Is that what you want me to do?
Yeah, absolutely. That's fine.
Mr. Rolla, is there any reason not to just get it on the trial docket?
No, Judge.
If I set it between 60 and 90 days, no sooner than that time period, would the people be ready to proceed to trial?
I believe that would be correct. Yes, Judge.
Would you be ready as well, Mr. Hillier?
That should be plenty enough time. Thank you.
Mr. Trush, I know that you're here an advisor, your standby role, but would that be acceptable to you?
Yes, Your Honor, it would. And I would indicate again, I think it, in a standby role, the role is somewhat murky, but if Mr. Hillier calls the office and makes an appointment to come in, I will help him get together witness exhibit lists, jury instructions, all of those things, so that he, can have all that prepared.
Well, I know what you say, I think, when you say murky, but let me explain to you how I view the role, and then I'll hear from you if you don't think it's accurate. The standby role is where you're there to provide legal advice and legal assistance if it's requested, but you're not required to do anything if it's not requested. So if Mr. Hillier reaches out to you and wants your input, you're there to be able to provide input to him, but you're not required to do it because you're not appointed to represent him. You're standby for Mr. Hillier's benefit if he asks for it. Do you have any objections to the court's characterization of your role or any questions about it?
No, Your Honor. What I mean by that is I don't think I necessarily have an obligation to prepare a witness list to file it for him or anything.
No, you have no such obligation.
And what I'm indicating to him is I am willing to assist him with doing those things if he wants to come into the office.
So, Mr. Hillier, it's a fair point for Mr. Trush to bring up. Did you hear how I just characterized his role?
Yeah.
Do you have any questions regarding how I characterized his role?
No, it sounds like, if I want him to help me, I'm gonna have to schedule an appointment and, meet in his office up there.
Well, you just need to be in contact with him to get all of those things set. But the point is, because he's standby counsel, since you didn't qualify for the appointed counsel role, your role is you're going to be representing yourself unless and until you seek his assistance. If you don't seek his assistance, he can't offer it.
Right, he's under no obligation.
That's right.
I understand.
Standby attorney. So I will set the trial. I'm not going to set any other hearings in between. It would appear to be a waste of time, but I'm going to set the trial. I'm going to set 2-day jury trial on the basis of the request by the people, and we'll see you on that trial date. Mr. Hillier, just remember, no later than 8:30 on the morning of trial is when I expect it required that you're in person, that your standby attorney is in person, and that Mr. Roll is in person. Any questions?
No, Judge.
Any questions? Mr. Hillier?
No, Your Honor.
Okay, thank you. We're all set today. Next, Mr. Sprague and.
Good morning, Mr. Brown.
Yeah.
And so by appearing this morning, I'm going to quash the warrant that was issued by the city of Longview. I'm going to give you 3 new court dates. Do you have a pen and paper available?
Yeah.
Okay.
No, I don't. Oh, I gotta go up front. I just want to. You got a pen and paper? Okay. I don't want them. I just want 1 court date because I'll get confused. And I need to get your phone number. Is this attorney?
No, this is the judge. I'm striking the warrant that was issued. I'm going to give you 3 new dates. You'll still need to contact your attorney after today.
I need to call the courthouse and get my attorney's number. I need to get on it. I've been lazy.
I can give you that. I can give you that number as well, Mr. Brown.
Give me the 1 court date. Just the first one.
I'm going to give you 3 court dates. The first one is May the 4th at 10 a.m.
All right. Hold on. May the 4th at 10. And Zoom?
Yes, that would be on Zoom.
What was it? What was it? I forgot. I said 10, May 4th? Is that what you said? May 4th at 10 o'clock?
I did.
All right. I'm not bad. I'm thinking something else. I want to tell you something. All right.
Mr. Brown, if you could just listen to me for 1 second, I'm going to give you 2 more dates. June the 29th at 9 a.m.
I'm not gonna bother writing them down. I can't even write the first one down. I'm like really confused. Oh yeah, I'm just gonna take a year GLC with that when I talk to my attorney. I don't want to go to jail. That's what I want to talk about. I can't. I'm not having a hard time. I'm frustrated.
I understand that you may be frustrated,
But
but
that's okay. I got the first court date. So when the next court date, they'll give me 3 more court dates. So it'll be all right.
no.
But yeah, I'm gonna try to get this handled. I don't want to keep going to court for the next 10 years. I mean, the last case strung out for over a year. Until I took a strike.
Mr. Brown, I'm also
I
going
ain't
to
nothing wrong.
Mr. Brown, I'm going to give you your attorney's phone number at this time. You ready to write that down?
Yeah, I can write it down. Give me a paper. Paper's so small. He gave me a little notebook paper. I write like a fucking 3rd grader. All right, what is it?
360.
360.
You need to call them and set up an appointment.
Okay, yeah, I do. He's booked out like a month. And I gotta get my number on my phone and write that down. So I just haven't had a pen and paper and everything. But yeah, I'm getting on to it. And before I can make any kind of deal, I have to go see him. So that's what my plan is.
That sounds like a good plan. I'm going to give you a couple more court dates. So we'll see you via Zoom on May the 4th at 10 o'clock.
I'm not going to be on my camera right now. I'm running out of paper. All right. I got the first court date. Every court date is 3 more, so it's okay. I did nothing wrong. You can prosecute me for this. Yeah, all right. Thank you. Is that it, Your Honor?
No, I'm going to advise you of 2 future court dates, June 29th at 9 a.m. in person at the Hall of Justice in courtroom 6, with a trial date of July the 10th at 9 a.m. also in person in courtroom 6. Call your attorney's office. They can remind you of those court dates if you're not able to write them down right now.
Okay. I need to get an afternoon appointment because but the reason why I missed court, Your Honor, is because I thought to see my attorney, I mixed up on my court date to the attorney, and I called them when I was with my appointment card. I didn't realize it wasn't. I thought it was an appointment card for to go to court. But I got it mixed up. That's the only reason why. I didn't even know I had a warrant.
I understand.
My DOC officer didn't tell me.
Mr. Brown, I'm glad that we were able to work this out and get the warrant quashed. So talk to your attorney. We'll see you back here on May the 4th. Thank you, sir.
All right, there we go. Bye.
Bye.
SM1. This is a case alleging attempting to resist and obstruct a police officer as counts 1 and 2 and count 3 as a domestic violence. So Mr. Jarboe, since you're here as the arraignment attorney today to assist Ms. Gilmore, have you had an opportunity to speak with her regarding these charges, the possible sentence, and also her rights?
I have. For purposes of the arraignment, we did discuss the charges and the potential penalties. She knows what those are, does not agree with them, but knows of what they are, and asked that please, if not guilty, be entered. She's waiving further reading of the misdemeanor complaint. She is going to be asking to be screened for counsel, court-appointed counsel.
Very good. So Ms. Gilmore, would you please raise your right hand? Do you solemnly swear and affirm the information you're about to give is the truth, the whole truth, and nothing but the truth?
Yes.
All right, we're going to be asking you questions for the purposes of your court-appointed attorney request and also for bond. Now, do you have a phone number you could give us, please?
9. Yeah. I don't really want the cops. I don't want the cops here listening to my stuff because they were just out here talking shady stuff, like talking about not fucking each other over and like stuff like that, like really weird, shady stuff. Yeah.
Okay. So, is the door closed so that you?
No, it's not closed. It's cracked open.
Okay, it is supposed to be cracked open a little bit, but
I don't trust them because of that shady conversation I just heard.
Okay. Well, as far as I'm not sure what trusting has to do with it, but it's usually for your own safety that they crack.
They're not talking safety wise.
Okay. So is there an officer right there? Just knock on the door and have him come here for a second.
I can see him right there.
Well, would you knock on? Officer?
Yes.
Are you able to close the door, or is it against your policy to close the door during arraignment?
Yeah, I can shut the door. I just can't have it locked.
Okay, very good. If you could just close the door, that'd be helpful.
Yes, Your Honor.
Thank you. Okay. Does that help a bit, Ms. Gilmore? All right.
Thank
you. Okay. So do you have an email address we can use? Do you have an email address we could use?
Yeah, I do.
Okay, you gotta back up a little bit. I have to be able to see you.
I don't want to talk. I don't want to talk loud enough for them to hear me.
Okay, well, I still have to be able to see you while you're talking.
See, just open the door. Because I don't want him hearing me.
Just leave the remotes alone. Thank you.
I don't want him hearing me.
Ms. Gilmore,
I don't want him hearing me.
that's fine.
But
I
he just turned the TV, he just turned the remote back up so he could hear me.
All right.
So he could hear you. He just
what
turned it
is your-
back up and now he's turning it up even louder.
Ms. Gilmore, what is your?
Now he's
what is
turning
your-
it up even louder.
What is your email address, please?
I'm not saying anything until he turns it back down. I
Okay,
don't
if
want
you're
him
not gonna
listening to my
say anything,
conversation. I don't want him
Ms.
listening to my conversation. I don't trust him.
Gilmore, if you do not cooperate and give us your email address, then we will have to, okay. Mr. Jarbo, I think we're going to have to adjourn this arraignment at this time.
Because
And
I don't
we
trust
schedule
them.
this.
Email.com.
Do you have any, thoughts on that? Mr. Jarbo,
No.
do you think we can, she's still talking. I think we're going to have to adjourn this for tomorrow.
Thank you.
Will you be with us tomorrow or are we going to have another
No.
IDC? All right, I will be the arraignment judge again tomorrow.
Well, you'll be prepared.
I'll be prepared, yes.
Thank you.
Okay.
Bye-bye.
All right. So Ms. Gilmore, we are going to have to adjourn this hearing today and we'll be talking with you tomorrow. Officer, we'll be doing this again tomorrow. At least we'll try. I've got it muted, so I can't hear a thing. That's a shame.
That's a shame. Thank you.